이잉원.
That's the end of questions. Motions. 4 proposed resolutions to be moved by the Secretary for Financial Services and the Treasury under the Bankruptcy Ordinance and the Companies Ordinance. The first motion seeks the Council's approval for the Bankruptcy Amendment Rules 2013. The second motion seeks the Council's approval for the Bankruptcy Fees and Percentages Amendment Order 2013. The third motion seeks the Council's approval for the Companies Fees and Percentages Amendment Order 2013. The fourth motion seeks the Council's approval for the Companies Winding Up Amendment Rules 2013. As the 4 amendment rules and amendment orders under the 4 motions are relating to the revision of the official receiver's office's statutory fees, charges, and deposits regarding the provision of the relevant services in respect of bankruptcy, and that the contents are closely related and were scrutinized by the same subcommittee, this Council will proceed to a joint debate on the 4 motions. I will first call upon the Secretary to speak on the 4 motions and move the first motion. When the debate comes to a close, this Council will first vote upon the first motion and then vote upon the second, third, and fourth motions respectively. Whether or not the first motion is passed will not affect the moving of the remaining 3 motions by the Secretary. This Council will now proceed to a joint debate. Members who wish to speak on the 4 motions will please press the Request to Speak button. I now call upon the Secretary for Financial Services and the Treasury to speak and move the first motion. Secretary. President, I move that the first motion under my name, as printed on the agenda, be passed to approve the Bankruptcy Amendment Rules 2013 made by the Chief Justice, CJ, on the 18th of June 2013. The amendment rules, together with the amendment orders and amendment rules covered in the 3 motions I am going to introduce, were all made by the CJ and are subject to the positive vetting procedures of the Legislative Council. These amendment rules and amendment orders seek to revise the fees, charges, and deposits payable to Official Receiver's Office, ORO, under the Bankruptcy Ordinance and the Companies Ordinance for the provision of services in respect of personal bankruptcy and company winding up. Regarding the statutory fees, charges, and deposits levied by ORO, it is our long-standing policy that government's fees should be set at levels adequate to recover the full cost of the services provided. This is to ensure that such costs do not fall on the general taxpayers. ORO has recently conducted a review of its statutory fees, charges, and deposits. After taking into account the existing levels of these fees, charges, and deposits, as well as ORO's actual operating revenue and costs, we project that ORO's cost recovery rate for the 2013-14 financial year will be 111%. We propose to reduce a total of 26 items of fees and charges levied by ORO for bankruptcy and winding up cases, as well as the deposits payable upon presentation of a bankruptcy or court winding up petition, bringing the levels back to those prior to the last fee revision exercise, that is, the levels in 1997. As regards the fee payable when the official receiver, OR, acts as the interim trustee or trustee in bankruptcy cases, or as the liquidator in court winding up cases, that is the realization fees, we propose to charge a fixed fee of $170 on a full cost recovery basis to replace the present mechanism of charging a fee of 10% of the assets realized. If the proposed fee revisions are implemented, it is estimated that the annual revenue of ORO will be reduced by about $17.3 million. Assuming that the revised fees come into effect before 2014, ORO's projected cost recovery rate for 2013-14 will be around 100%. As far as the first motion is concerned, that is the Bankruptcy Amendment Rules 2013, The amendments will reduce the two types of deposits payable by a petitioner upon presentation of a bankruptcy petition. The deposit for debtor petition bankruptcy cases will be reduced from $8,650 to $8,000, while that for creditor petition bankruptcy cases will be reduced from $12,150 to $11,250, both reverting to the levels in 1997. For the second motion, that is the Bankruptcy Fees and Percentages Amendment Order 2013, the amendment will adjust downwards 13 items of statutory fees charged by ORO for administering bankruptcy cases, while the mechanism for charging the realization fee when the official receiver acts as the interim trustee or trustee in bankruptcy cases will be replaced by a fixed fee of $170. For the third motion, that is the Companies Fees and Percentages Amendment Order 2013, the amendment will adjust downwards 12 items of statutory fees charged by ORO for administering winding up cases, while the mechanism for charging the realization fee when the official receiver acts as the liquidator in court winding up cases will be replaced by a fixed fee of $170. For the fourth motion, that is the Companies Winding Up Amendment Rules 2013, the amendments will reduce the deposit payable by a petitioner upon presentation of a court winding up a petition from $12,150 to $11,250. Besides a fee charged by ORO to cover the costs of summoning meetings of creditors or contributories in relation to the winding up proceedings of companies will also be reduced from $1,560 to $1,440. President, I would like to thank the chairman of the Reverend Leschko's subcommittee, Mr. Wong Ting Kwong, and his members for their efforts in vetting and offering views on the various amendments at meetings of the subcommittee. I hope this Council will support this motion so that ORO can implement the proposed reduction in the deposits for bankruptcy cases as soon as possible. I move that the motion be passed. Thank you. I now propose the question to you, and that is that the motion moved by the Secretary for Financial Services and the Treasury be passed. Mr. Wong Ting Kwong.
Thank you, Mr. Deputy. As the chairman of the subcommittee on resolutions under the Bankruptcy Ordinance and Companies Ordinance, I report to this Council the deliberation of the subcommittee. The subcommittee had two meetings to study the proposed resolutions and listened to the views of the deputations. The four resolutions under the Bankruptcy Ordinance and Companies Ordinance seeks to reduce the fees, deposits, and charges in respect of the bankruptcy and winding up procedures. And such fees and charges will be reverted to the level prior to the previous adjustment in 1997. After the reduction, the official receiver's office is expected to have its cost recovery rate reduced from 100% to 111% to 100% in the year 2013-14 financial year. The subcommittee supports the administration's proposal of cost reduction, and the subcommittee is concerned about the deposits which could be further reduced by the ORO. The administration explains that the deposit will be reduced from $8,650 to $8,000. The sum of money is to pay for the costs and expenses incurred by the official receiver's office in respect of, say, putting up notice in the Gazette and newspapers about the bankruptcy case, conducting search of information, administrative and administration of assets. The fee of $8,000 is reasonable. The subcommittee is concerned that some of the debtors may be in financial difficulties and may have difficulties in paying for the deposits. They may have to seek the help of illegal moneylenders in order to pay for the $8,000. The subcommittee discussed various means to give assistance to low-income debtors in applying for bankruptcy. The proposals include paying the deposits by installment, and if the debtor is not able to pay the installment in full, the bankruptcy period can be extended. There is also the proposal to reduce the deposits for the elderly, for the disabled, and for the applicants who have no income in the previous 3 months before bankruptcy. The administration has advised that if the deposit is reduced to less than $8,000, that will compromise the objective of the ORO in cost recovery on a general basis. In other words, the expenses will be paid by the general taxpayers. In respect of comparable jurisdictions such as UK and Singapore, there is no other mechanism to lower or waive the fees or deposits to be paid by the applicant for bankruptcy. As for paying the deposit by installment, the administration is the view that there will be legal and operational problems. According to the general principle of bankruptcy laws, any contribution by the bankrupt to his estate is regarded as an asset and will be distributed to all the creditors according to priority. Paying the deposit by installment means that the contribution or the installment should first be used to pay for the balance of the deposit, and this implies that the debt of the official receiver has priority over the debts of other creditors. The administration is of the view that the proposal will undermine the interests of other creditors. The proposal to pay deposit by installment will cause the ORO to change its administrative procedures, and there will be more workload and will have implication on resources, thereby reducing the rate of cost recovery by the ORO. As for setting up a mechanism to further extend the bankruptcy period until the deposit is fully settled, the administration is of the view that there is no justification to indefinitely extending the period of bankruptcy simply because a particular debt is not paid. The subcommittee is of the view that the issue of providing financial assistance to the bankrupt should be followed up from the perspective of social welfare. Members also agree that the subcommittee is not the suitable platform to deal with such matters. Members may pursue the matter at the meetings of relevant panels. The subcommittee supports the administration's proposed resolution and will not move any amendment. Mr. President, I will express my views on the proposed resolution as follows. The resolutions are not controversial. They are just about adjusting fees and charges to enable the ORO to reduce fees and charges in relation to bankruptcy and winding up procedures. Is also related to reducing deposits. In doing so, the cost of recovery rate will be reduced from 111% to 100%. After the adjustment, the ORO will be able to recover costs on a general basis, and the burden on the applicants will also be reduced. The DAB therefore welcomes such resolutions, and we will support the resolutions. During the study of the resolutions, the main issue is on the ways and means of assisting the applicants, the low-income applicants who have no means to pay the deposits. Some members and also the Caritas Families Crisis Support Center have opined that some debtors are not able to pay the deposit, and they are not able to obtain assistance from their families or relatives, and they have to turn to the illegal moneylenders to seek help. Now, they face difficulties to make a living, and they also have to suffer from serious psychological pressure. Therefore, there are proposals, including a tier system, charging different levels of deposits depending on their incomes or means, or allowing the elderly, the disabled, the unemployed to have their deposit reduced or waived. And there is also the proposal of paying by installment. And there is another proposal to extend the bankruptcy period. I've already reported to the Council in the report. I just want to point out that the fees charged by the ORO is to pay for the costs and expenses incurred in dealing with the bankruptcy procedures. It should not be confused with the issue of helping the debtors. The ORO is informed us that there are about 10,000 applications for bankruptcy. From 2008 to 2012, 13% of the applicants didn't have any income. 40% had income less than $10,000. I think reducing the fees will not be a way to help the applicants to deal with their difficulty in living and in paying for the petition. Now, using they petition for bankruptcy in order to deal with their financial problems, to deal with those debtors who have difficulties in making a living. The administration should provide suitable help. The ORO is not in a position to distinguish those who have genuine needs. Social workers should be involved in following these cases, and the debtors should be assisted through social welfare channel. One should not just help them to deal with the debt problem. One should help them by a whole person approach. If just by reducing the petition fees, that is only a piecemeal measure and is not appropriate. We support the resolutions made by the administration, and we should separate the fees and charges from helping the applicants. And the ways and means of helping the applicants should be discussed by the relevant panels. I agree with some members that the ORO and the SWD should set up a referral arrangement. The ORO may refer cases to the SWD so as to help the debtors. The government departments shouldn't just guard their own turf. They should enhance their support, their cooperation, in order to reduce conflict and forge harmony in society. I urge the departments to consider this proposal. Finally, I want to speak on illegal money lending. We've heard that there are debt collectors who harass the debtors and their family members. And these debtors and their families are living under threat. They seek help from the government, yet the police just put ask for help on record, and the police is unwilling to intervene. The law protects the debtors and family members from being harassed, yet the law also gives rights to the creditors to collect their debts. So, in fact, harassment is a gray area, and the police finds it difficult to intervene. I hope the administration will pass laws to restrict excess harassment, and there should be provisions to enable the police to intervene when the harassment goes to the extreme. Debt collectors should not be allowed to go to the extremes to harass the debtors and their family members. The debtors and family members should be allowed to lead a normal life. Mr. Deputy, thank you.
Mr. Tan Ka Pio. Thank you, Mr. Deputy. The subcommittee chairman, Mr. Wong Ting Kwong, said that different departments shouldn't just be doing their own things. Well, this proposed fee adjustment has brought up this discussion. I think is good. Finally, there's a platform at LegCo for individuals heavily laden in debts could explain what is the plight they face. It's not just about repaying debt. Now, in the face of crisis, what can they do? If they couldn't find another way, okay, they will just have to file for bankruptcy. And when they would just want to give up, they find they have to pay, and so they have they are cornered. And as some suggested, they may have to borrow to file bankruptcy, so they end up with more debt. And some have to actually borrow from illegal money lenders. Some end up having to hide or even commit suicide. So it's a good opportunity for us to raise these issues with the presentation of these resolutions. I welcome the resolutions proposed by the administration so that the petition deposit will be reduced from $8,650 to $8,000. That's for bankruptcy cases. And then for winding up cases, the deposit is also reduced to $11,000. Now, a downward adjustment of $650 would offer a little bit of help or relief to those who need to file for bankruptcy. But still, there are many debtors who cannot afford the $8,000 of the application fee. Of course, there's another $1,000 they have to pay to the court, so it's more than just $8,000. Even if they file their own petition, they have to pay $9,000 as a minimum. Now, in Hong Kong, we all attach great importance to our financial credit. No one would just file bankruptcy casually, because once you've filed bankruptcy, you'll be subject to a lot of restrictions in your life in the next 4 years. And then later on, when you want to borrow money or start your own business or take up certain jobs, you may not be able to do so. That's why no one would casually file for bankruptcy. Now, the fees for filing bankruptcy is some $9,000, $8,000 in deposit. It's still a large sum of money. It's about we're talking about people who have no other alternatives. May have used all the resources and the resources of their family network. Still, they could not repay the debt. It's only then they have to file for bankruptcy. But now they face the hefty deposit and fees. Now, Mr. Wong Ting Kwong said that we ought to regulate debt collectors' activities. But I think we also have to regulate the lending of money. Now, there is advertisement placed by many lenders. You get calls, and there are stand-up frames on the street. The advertisements is everywhere. They claim that even if you have low income, there is a quick approval. It's easy to borrow and it's easy to repay. You just need phone number, an address, and an ID card number. You can apply for loans, and as if you don't need to repay your loans, but of course the interests are high. And then maybe there's other cases that someone has not borrowed any money, but they become the guarantors and they get into trouble. And there are also consumer cases reported in the media. That is, people go to fitness club or certain organizations, and they say, well, our membership fee is our membership enrollment is cheap. They just need to pay $10,000 every month. You only need to repay $500 each month. And at the end, people find out they've actually signed a loan contract. Now, there are people not in a good mental state, maybe ex-mental patient, because they may succumb to persuasive marketing, and they end up with a lot of debt. So easy lending is a problem, in addition to illegal debt collecting. And university students, some may be able to apply for 5 or 10 credit cards. We've all read about that in the news. Banks are rather liberal in approving credit card applications. Actually, they have aggressive marketing as well. Now, even if the applicant does not meet the relevant income limit, he may still get a credit card, although he may get a smaller credit amount. And if someone has zero income, he may not be able to repay his credit card bills. Well, shouldn't banks watch that carefully? As I said, there are many tertiary institute students finding themselves in debt. And for grassrooters, they could not afford to repay their financial debt. They have no choice. At the end, the only means available to them is to file for bankruptcy. And then they find out they have to pay hefty fees, and that's a nightmare to them. Now, the Characters Family Crisis Support Center, and that's the also the concern group on Hong Kong personal credit problem under the Characters Family Crisis Support Center. Well, they came to see us. They shared with us some of the individual cases. Maybe it's a tertiary institute student overspending, or some just innocent guarantors. And there are other cases, people just run out of money. They can't make ends meet, so they have to borrow money. And there was a woman member of the concern group who shared her story with us. She used to live. She lived with her family, her husband and son. But the husband always had debt problems, and then she borrowed $100,000 from the bank to help her husband repay his debt. But then the husband just vanished. So this woman had to pay, shoulder the debt, and she had to also support the family. Now, this woman just works in the factory. She earns $6,000 a month, and she saves hard, and she only has $1,500 to pay the debt every month. At the end, she has borrowed from everybody, even her family members, her relatives, and then at the end she chose to file bankruptcy, but she found out she had to pay $9,000, so she didn't know what to do. At the end, her family members helped her out as the for the last time. But then now during festive seasons, this woman could no longer see her relatives because they are all afraid of her now. And there's some district councillor has helped grassroots and debt problems, not just the financial crisis, that could lead to other problems because some, well, may borrow from relatives, but others may choose to borrow from loan sharks. Some have no choice. And on the spur of the moment, while Mr. Wong Ting Kwong said it's a band-aid approach, but because people are anxious, they may choose to make a stupid decisions. Now, there was quite study on debt behavior and how it may on debt and how it may cause people to commit suicide. It's found that in every 4 cases of suicide, 1 is related to debt. But of course, that was in after 2003. There was SARS. There was the internet bubble bursting and so on. Still, you know, in suicide cases, it's 2 men to 1 woman. And very often, for the middle-aged men who committed suicide, it was related to debt. So it's not about trying to help people to save on filing bankruptcy, but rather we see life crisis, we see family tragedies. When people want to give up, they want to file for bankruptcy, they find they have to pay $9,000 at the end. They made a stupid decision or silly decision. So I hope all the departments will work together to deal with these cases. Now, if we lower the fees, would we encourage people to file for bankruptcy? As I said at the beginning of my speech, no one would file for bankruptcy, even if the fee is 0, because it will affect your personal credit, it will affect your job prospects. You might not be able to borrow in future when there's a need to. And people may say that people may tend to spend more if it's easy to file for bankruptcy. But the Characters Family Crisis Support Center found that 1/3 of those in debt because they couldn't make ends meet, so they keep making loans, and the loans add up. Or it could be a case that, say, a family member is severely ill, or maybe one of the children has to go to tertiary institute, and there are hefty tuition fees. Of course, some people end up in debt because of gambling, but a lot of the people in debt are those in the grassroots sector, some 60%. Before bankruptcy, for those with a monthly income of less than $1,000, 80% of these bankruptcy cases are people with monthly income of less than $10,000. So the government has to find ways to help people here at risk. Now, Mr. Wong Ting Kwong mentioned suggestions from some groups, for example, a tiered system of deposit or payment of deposit by installment. I hope the government won't turn its back to all these proposals so soon. Or, of course, we could consider amending the legislation so that maybe the ORO should be the first creditor. But of course, the Inland Revenue Department may complain because then people may not pay tax first. In fact, social support is important. I see Mr. Cheung Kwok Chi has indicated his wish to speak for the disadvantaged. Now, if it's the same pot of money, do we use it to help people to repay that, or do we use it for buying medicine? Now, within the ORO's system, I hope that we can address this issue. Please do not use other public resources to help these people. Otherwise, it would just lead to other problems. Now, Mr. Kwok of the Characters Family Crisis Support Center has also suggested if we build establish a system, a mechanism, what happens? Very often the buck will be passed to the Integrated Family Services Center. Now the social workers may not be able to deal with it, and it's about debt problem. The debt collectors may be at your heel already, and you may not be able to put up with the stress. But then you have to go through a referral system, interviews have to be scheduled, and there will be counseling and so on. But that will be too late. So, of course, social workers, it's their job to help people, but then they cannot resolve all issues instantly. I think we should look at the fee structure of the ORO. That is the way to address the issue at root. Now, the FTU supports the resolutions, and we're concerned about the debt problems of grassroots. And I hope we will just leave the matter as it is now. I hope we will still do studies, and we must really help to try to help people at risk. Otherwise, we may end up paying more social costs.
Mr. Chiang Kok-chi. Thank you, Mr. Deputy. Mr. Wong Ting Kwong and Mr. Tan Ka-Piu has already spoken a lot, which I intended to speak. Well, let me do some sort of wrapping up. If you owe people money, you should pay. And people only apply for bankruptcy if they are unable to pay. Now, it is said that some people make use of bankruptcy as a means to escape debts or to avoid paying debts. But how many times can you repeat this act? We can see people who didn't borrow any money, but they were in debt. Say they were guarantors. Mr. Tan Ka-Piu mentioned the case. The husband borrowed money and then fled. The wife, who was the guarantor, had to bear the debt. She has to take care of the family. At the end, she has to apply for bankruptcy. I've also come across another case. A CSSA family. The daddy was a CSSA applicant. There was a mentally retarded child. One day, the son came back and said he helped somebody by being a guarantor. The one borrowed money, fled, and then the mentally disabled child, who was also an adult, had to pay for the money, pay for the loan. And then the CSSA family, how could a CSSA family repay the debt of $10,000? Maybe the family had to pay $10,000 in terms of loan, but the family would have to pay $9,000 in order to petition for bankruptcy. The resolution is to reduce the government's fee, but the ORO refuses to compromise by allowing a tiered mechanism for deposits or by waiving the deposit. The administration can actually set up a fund to do that, but the administration refuses. I cannot change the fact, but in the reply by the policy secretary, can he tell us in his reply and also in moving the resolutions, can he inform this council that the administration will consider the difficulties of these low-income families? Well, if that is not something that can be done by the ORO, can you refer these issues to the relevant departments? We are concerned about the poor. If the government doesn't help, individual citizens cannot help much. Well, the poor will continue to borrow money, and then they continue to apply for bankruptcy. I think to get out of this quagmire, only the administration can help. I think the government departments can follow the matter up. And I really hope that within a short period of time there can be a reply. Say, for example, the SWD can help as long as they ask, as long as they can fulfill certain criteria. It's okay to set the criteria. Yet, if there is no safety valve for these low-income people, and if they can only apply for bankruptcy, then the problem cannot be resolved.
Does any other member wish to speak? If not, I now call upon the Secretary for Financial Services and the Treasury to reply. The debate will come to a close after the Secretary has replied. Secretary? President, I would like to thank Mr. Wong Ting Kwong, Mr. Tan Ka Pio, Mr. Chung Kwok Chi for speaking in this debate. Now, Mr. Tan Ka Pio proposes to offer assistance to a certain group and also to further reduce the deposit level. Now, the recent review conducted by the ORO is that if the new fees could come into effect in this financial year, then the cost recovery rate would only be 100%. If we further reduce the deposits paid by a particular group of people, then the ORO will not be able to recover the full cost, and that means the service will have to be subsidized by taxpayers' money. So in other words, taxpayers will have to subsidize individual bankruptcy petition cases. It's not fair to taxpayers. The cost for bankruptcy petitions ought to be shouldered by the debtors themselves. And then many petitioners of bankruptcy cases may claim they could not afford the relevant fees, so it's difficult to come up with a system that is fair and acceptable to stakeholders in reducing fees. That's why it is not appropriate for us to set another statutory mechanism in offering relief to deposits of fees paid by a particular group of people. As I said, the 4 resolutions seek only to reduce the certain fees, charges, and deposit. If the resolutions are approved by the Legislative Council, then the new fees will come into effect this year. The resolutions have been considered in detail by the subcommittee, and the subcommittee has expressed its support for the resolutions. I therefore ask members to pass the resolutions to approve the Bankruptcy Amendment Rules 2013, the Bankruptcy Fees and Percentages Amendment Order 2013, the Companies Fees and Percentages Amendment Order 2013, and the Companies Winding Up Amendment Rules 2013. Thank you. And I'll put a question to you, and that is that the first motion moved by the Secretary for Financial Services and the Treasury be passed. Will those in favour please raise their hands? Those against please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Secretary for the Financial Services and the Treasury, you may now move to second motion. I move that the second motion under my name as printed on the agenda be passed to approve the Bankruptcy Fees and Percentages Amendment Order 2013 made by the Chief Justice on the 18th of June 2013. And I'll propose a question to you, and that is that the second motion moved by the Secretary for Financial Services and the Treasury be passed. And I'll put a question to you as stated. Will those in favour please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Secretary, you may now move to third motion. President, I move that the third motion under my name as printed on the agenda be passed to approve the Companies Fees and Percentages Amendment Order 2013 made by the Chief Justice on the 18th of June 2013. And I'll put the question to you, and that is that the third motion moved by the Secretary for Financial Services and the Treasury be passed. And I'll put the question to you as stated. Will those in favour please raise their hands? Those against please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Secretary, you may now move the fourth motion. President, I move that the fourth motion under my name as printed on the agenda be passed to approve the Companies Winding Up Amendment Rules 2013 made by the Chief Justice on the 18th of June 2013. And I'll propose the question to you, and that is that the fourth motion moved by the Secretary for Financial Services and the Treasury be passed. And I'll put the question to you as stated. Will those in favour please raise their hands? Those against please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed.
議員就附屬法